Hi, my name is Mark Randall and I'm a county court judge in Jefferson County.
And my name is Michelle Amico, and I'm a district court judge in the 18th Judicial District, which is Arapahoe, Douglas, Elbert, and Lincoln counties. We are going to talk to you today about preliminary hearings and proof-evident presumption great hearings. We have prepared written materials which we hope will be very helpful to you, which will be available on the website. Our goal today is to cover some of the highlights in those materials and some of the issues that often arise in these hearings. In general, preliminary hearings, also called PHs or prelims, are conducted in the county court divisions, but there are occasions when a district court judge will conduct a preliminary hearing. So I'm going to turn it over to Mark to discuss PHs.
Thanks, Michelle. It is important to understand the purposes of a prelim. It is often called a screening device, as it is the hearing afforded a defendant in which the government must show there is sufficient evidence for the case to go to trial. Sufficient evidence is basically defined as probable cause, which is the burden at the hearing. The first question is the defendant entitled to a PH? It is important to understand that a prelim is a statutory right, not a constitutional right. And as it is created as a statutory right, the legislature has limited when a PH is available by both the type of charge and by time. This is explained in 16.5.301 and Crim P Rules 5 and 7. As to time, inaction by the defendant will prevent there being a PH, as it must be requested within 7 days of when charges are filed. As to the limitation of the type of charge, there is no right to a PH on misdemeanors or grand jury indictments. There is only a right to a PH if the defendant is charged with a Class 1, 2, or 3 felony, or a Class 1 or 2 drug felony, or if the charge carries a mandatory sentence, is a crime of violence, or a sex offense, regardless of if the defendant is in custody. Or, if the defendant is in custody for a felony charge, there is a right to a preliminary hearing. But make sure the defendant is in custody for that charge and not on another case or for a different county. So as the judge, you need to make sure that the defendant is eligible for a prelim and what charges the prelim right attaches to. You might be doing a prelim on count 1, but not on counts 2, 3, 4, or 5. Each count is looked at separately, and you only need to make PH findings on the count or counts that are PH eligible. Also, substantive offenses are the only ones that matter for PH purposes. There is no right to a PH on sentence enhancers or habitual criminal counts. As a good practice step, you should verify with the prosecutor and defense attorney at the start of the hearing what counts you are proceeding on in the PH to make sure everyone is on the same page before the testimony begins. The timing of the hearing is also very important. It must be held within 35 days of the date it is requested. Continuances past the 35-day deadline can happen if good cause is shown to the court. At the hearing itself, the rules of evidence may be tempered in the use of sound judicial discretion, and the rules of evidence themselves state that the rules do not apply to preliminary examinations in criminal cases. Therefore, hearsay can comprise the bulk of the evidence in a PH. However, there must be some competent non-hearsay evidence, direct evidence, that addresses an essential element of the offense, and the hearsay evidence should be presented through some witness connected to the offense or its investigation. Direct evidence can include such things as the demeanor of the victim, a police officer viewing the injuries, or a statement by the defendant, etc. When you have heard the evidence, you must decide if PC has been proven. In making this decision, you must consider the evidence in the light most favorable to the prosecution, and all inferences must be resolved in favor of the prosecution. A way to look at it is this: if person A says X and person B says Y, if X is the prosecution theory, then the case is bound over. It may seem like a very defensible case, with potentially strong affirmative defenses, suppression issues, etc. It still gets bound over if in the light most favorable to the prosecution, probable cause has been established, even through mostly hearsay. The issue will then arise: what is the defense role in cross-examination? The criminal rules do allow the defense to cross-examine prosecution witnesses and to introduce evidence. The right to cross-examine and to introduce evidence may be curtailed by the court consistent with the screening purposes of a preliminary hearing. However, the court may not completely curtail inquiry into matters relevant to the determination of probable cause. Many defense attorneys want to gain as much information as they can about the prosecution's case at the PH. They will ask a lot of questions which may be discovery-related or designed to set up a motions issue down the road or to try to lock an officer into certain testimony for future proceedings. Affording the defense an opportunity for discovery is not the purpose of a prelim. Also, the court does not decide suppression issues at a prelim, so the court would have the ability to limit the questioning in these areas. The defense may also want to cross-examine or call witnesses in the area of credibility, such as calling a witness opposing the facts the prosecution established, or cross-examining the police about what others may have said. Remember that at the PH, the court will consider the credibility of witnesses only when, as a matter of law, the testimony is implausible or incredible. When there is a mere conflict in the testimony, a question of fact exists, and the court must draw the inference favorable to the prosecution. Testimony is incredible as a matter of law if it is as to facts which the witness physically could not have observed or events that could not have happened under the laws of nature. So in the vast majority of situations, you are not deciding credibility. Thus, the right to cross-examine may be curtailed in all but the most unusual circumstances. You may also encounter a request from the defense to call a witness at the preliminary hearing. For example, the defense may subpoena a domestic violence victim, anticipating that they will get on the stand and say something different from what the police say was reported. The prosecution can, and often will, move to quash the subpoena. The prosecution objection is often based on the premise that even if the victim takes the stand with a new statement, the prosecution will still have met their burden of probable cause, again in the light most favorable to the prosecution, and that any other purpose for discovery, etc., is simply not allowed. As a practice tip, it is rare that the defense will call a witness. As the judge, what you are looking for is an offer of proof that goes to the heart of probable cause, the heart of the probable cause determination, such as an issue of identification as shown by a case in the outline. When your ruling is complete, if you find probable cause, the case is bound over to district court for arraignment. If you do not find probable cause on a count, the others are still bound over. You can bind a case over on a lesser included offense as well. Remember, a PH does not apply to misdemeanors, and you have no authority to dismiss any misdemeanor accounts. They remain in county court if the felonies are not bound over, or if they are bound over with any felony counts to the district court. Likewise, the district court does not have the power to allow another PH or grant a PH when it has already been waived. Remember, the PH right is statutory. So now let me turn this over to Michelle to talk about when a PH will be held in the district court as opposed to the county court, and for the subject of proof-evident presumption grade hearings.
Thanks, Mark. In general, the district court will only be conducting a PH when the prosecution adds a felony count after the case has been bound over to the district court that is PH eligible, as Mark has discussed, or when you are conducting a hearing to determine both probable cause and proof-evident presumption grade, often referred to as a PEPG. The Colorado Constitution establishes an absolute right to bail, except where a capital crime has been committed and the proof is evident or the presumption is great that the person charged committed the crime charged. Many people think a capital case only means a case in which the people are seeking the death penalty. A capital case is a Class 1 felony that carries a mandatory life sentence, so just be mindful that first-degree murder, for example, is not the only Class 1 felony in the statutes. So, when you have a first-degree murder case, the district court judge will conduct a combined PEPG hearing, and in one hearing, be required to make two distinct determinations. One, has the prosecution established probable cause? And two, have they met their burden that the proof is evident or the presumption is great that the defendant committed that capital offense? Everything that Mark has just discussed regarding PHs will apply to your findings in this combined hearing as related to probable cause. However, the prosecution's burden in order to warrant a denial of bail is greater than merely proof of probable cause. They must demonstrate through their evidence that the proof is evident or the presumption great that the defendant committed the crime. So, how does case law define that the proof is evident or the presumption great? Gladney v. District Court is the primary case. It is in our outline, and it defines PEPG as something greater than probable cause, but less than the standard of proof beyond a reasonable doubt. Case law in this area is sparse. However, the term proof is evident is the proof of guilt. So you can think of this PEPG phrase as the proof of guilt is evident. Gladney relied upon a Supreme Court case of New Jersey, where the court in applying a constitutional provision almost identical to Colorado's provision, stated that bail should be denied when the circumstances disclosed indicate a fair likelihood that the defendant is in danger of a jury verdict of first-degree murder. Sometimes judges think of this as a great likelihood the defendant will be convicted of the crime at trial. But again, keep in mind, the prosecution's burden is something less than proof beyond a reasonable doubt. This is the legal difference between probable cause and PEPG. Practically, what does this mean? The prosecution not only likely will, but needs to give you more evidence than you would allow or expect at a PH. In addition, the defense is going to examine in expanded cross-examination and may make a greater effort to call witnesses themselves. The hearing will be lengthier. So, a tip here. Many of these combined hearings take either a half-day setting or even a full-day setting on your docket. So make sure that you set aside enough time to hear the evidence and make your findings. You can see from the legal definition of PEPG that you have a lot of room to exercise discretion. You will face a greater challenge here about how much, if at all, you allow the defense to negate from the prosecution's case in determining PEPG. Mark talked about how affirmative defenses are not something you need to consider in ruling on probable cause, but in your discretion, you may now permit yourself to consider this as to your decision regarding denial of bail. Let me provide you with two examples. One is a charge of first-degree murder after deliberation and with intent. The case alleges a husband stabbed his estranged wife to death. At the hearing, the evidence shows there was a protection order in place, the defendant forced entry into the home, the wife was stabbed multiple times in the chest, the defendant was seen running from the home, the knife had her blood and his prints, and he confessed. The likely ruling is that the people have established both probable cause and PEPG, and you will deny bail. Proof of guilt of first-degree murder is evident. The second example is more challenging. Again, the charge is first-degree murder after deliberation and with intent. This time, the case alleges ex-boyfriend shot new boyfriend one time in the chest, causing death. At the hearing, the evidence shows a history of bad blood between the defendant and the victim, with threats going back and forth, and at the time of the shooting, the victim came out of the house armed with multiple weapons and advanced toward the defendant, who then grabbed a gun from a car and fired one time. You will likely find probable cause, but your PEPG finding can be more challenging because of the self-defense issue. It is for you to decide how much weight you afford the affirmative defense. This might be an example where you decline to find PEPG and set bail, and you should utilize the statutory factors for bail in setting bail. If you find PEPG, you must deny bail and order a no-bond hold pending trial. If, however, you don't find PEPG, that is when you must set bail. We have shared with you some of the nuts and bolts, what the law and rules are, but we want to share a few thoughts with you that you can't find in an outline or in a statute book or even on Westlaw. Mark, do you want to share a few thoughts from the county court judge's perspective?
Yes, Michelle. One of the most important things I can convey is that your ruling must be clear and concise as to what your findings are and make a ruling as to each count that is eligible for a PH. What I would strongly caution you not to do as a judge is comment on the strength of the case. This is a huge trap that is so easy to fall into because you just heard some evidence and the defense made their best argument, and in most instances, you're going to rule against the defense. It is really tempting in your oral ruling to throw the defense a bone and say something like, well, this is a close case, but in the light most favorable to the prosecution, I have no choice but to bind it over. Both prosecutors and defense attorneys hate this. Prosecutors hate this because they know they have only given you a fraction of their evidence, and this type of comment frustrates them, and it might frustrate a victim in the audience. Defense attorneys hate this because they have to build rapport and trust with their clients. You as the judge don't know everything. There might be a good reason why the defense attorney believes it is best for their client to take a plea bargain or hear the evidence. You the judge, just told the defendant the prosecution's case is weak. This can damage that attorney-client relationship. So as a judge, just rule and stop. Don't interject your personal opinion or feel you need to say more. Michelle?
I completely agree with that, Mark. Make clear and concise findings, both as to probable cause and PEPG. It is even more important that you don't interject your personal opinion about the strength or weakness of the case, because in this combined hearing, you are the judge who will preside over the entire case. Your opinion now may carry greater weight with everyone listening to you. Explain your ruling. Those in front of you are entitled to it, but use the standards and case law to guide your ruling. Take that example I gave you of the self-defense case. You have decided the prosecution has not met their PEPG burden, and you are going to set bond. How do you say that without saying, I'm setting bond because this is a great self-defense case? Maybe something like this. My findings are limited to the evidence offered today that applies to limited and specific findings. Here is the law that I must follow today. Then outline the standards and apply your findings, focusing your words on how your ruling is applicable to the present state of the case. Our biggest piece of advice is to be straightforward and be boring.